Hello, everybody, and welcome to week 2 of our AP review. We are reviewing for the AP Government and Politics exam, so getting everybody ready for take that test next month. Last week we did founding documents, and so those recordings are on the website if you wanted to catch up on the founding documents. But today we are doing these Supreme Court cases, so these landmark Supreme Court cases that are included on the exam. So here to take us through all of these cases and answer all of our questions is one of our top scholars, Tom Donnelly. Hi, Tom.
Hey, Jenna.
All right, so students, we're going to dive in and we're going to go really quick because 30 minutes for 15 cases is not a lot, but we will get through them together. But please, if you have any questions or anything you want us to clarify or dig into deeper, please put it in the chat or the Q&A. And if I can, I'll yield it to Tom. But if we moved on by that point, stick around because we'll stay a little bit after class to answer any clarifying questions for you. But I will try to get to them as we go. So we do have these 15 cases. Like I said, we're not going to go quite in chronological order. We're going to be following the groupings that the AP and College Board have kind of set out in their framework. But we are going to start at the very beginning because I think this is an important case to understand the Supreme Court and where these cases come from. And that is with the first case, Marbury versus Madison, and kind of this idea of judicial review. So Tom, tell us about Marbury versus Madison and why it's important.
Sure. So Marbury versus Madison, it's 1803. The opinion is by Chief Justice John Marshall. The big thing to pull out of Marbury versus Madison, Jenna has already previewed, which is that it establishes the power of judicial review. And so this is the idea that courts have the power to review laws passed by the government or actions or practices of the government and say whether they're constitutional or unconstitutional. Marbury versus Madison itself has a really complicated back pattern and an interesting cast of characters. It involves John Adams, Thomas Jefferson, James Madison, and then William Marbury, who's the unknown here, but he's in a way the hinge point of the case. So what's Marbury complaining about? He's saying that in the closing days of the John Adams administration, John Adams had signed a commission for him to become a justice of the peace. So Marbury wants to be a justice of the peace, which is kind of a judicial official in Washington, D.C. But the new administration, Thomas Jefferson and James Madison, refused to deliver him his commission. So he can't take his seat. So this commission is sitting there in James Madison's office as Secretary of State on his desk, and Thomas Jefferson saying, don't deliver it to the Federalists, William Marbury. In the end, Marbury comes to court and asked Chief Justice Marshall to give him his commission. So he's saying, Chief Justice Marshall, issue an order saying James Madison has to give me this commission. John Marshall comes in this opinion and he says, one, William Marbury, you're right. You do have the right to this commission. It was signed and sealed by the President of the United States, but it was never delivered to you. At the same time, we, the Supreme Court, do not have the power to order James Madison to deliver you this commission, so you are out of luck. Why is that? Well, John Marshall says that we, the Supreme Court, have to look at laws passed by Congress and ask whether they're constitutional or unconstitutional. And here, the Federal Judiciary Act of 1789 does give us the power to issue this order, but in the end, that act is unconstitutional. So as a result, John Marshall, on the one hand, is saying we don't have the power under this act. The Congress doesn't have the power to pass this act and give us this power, but we, the Supreme Court, do have the power of judicial review to look at this act of Congress and say whether it's constitutional or unconstitutional. In this case, it's unconstitutional. So Marbury, you're out of luck.
It's kind of a 180 on Marbury. He's, thinks that the Supreme Court has this power but from this Judiciary Act, but it's actually the Judiciary Act itself that they say is unconstitutional. Congress had no power to pass that act and give them that power. So that means that Marbury is a little bit out of luck, but the Supreme Court itself gets a huge power of judicial review from this case. Do I have that right, Tom?
Absolutely. Judicial review becomes an important part of the Supreme Court's history from this point onward.
Okay, cool. All right, so we're going to move on to the next grouping, which is about federalism. So that relationship between the federal government and the state governments and kind of that push and pull, which has been kind of at the heart of our government since the Constitutional Convention. There's been a couple of Supreme Court cases that have dealt with this matter. So let's talk about the first one, which is McCulloch v. Maryland in 1819.
Yeah, so McCulloch v. Maryland, we're still in the Marshall Court here in 1819. McCulloch v. Maryland is a unanimous decision written by Chief Justice Marshall, and it weighs in on one of the most important constitutional debates in early America, and that's whether or not Congress has the power to charter a national bank. This debate began in the Washington administration. Alexander Hamilton said, yes, Congress has this power. Thomas Jefferson said, no, Congress doesn't have this power. And this issue finally gets to the Supreme Court in 1819. Here we see the state of Maryland in conflict with McCulloch, who was an official of the National Bank. Maryland has passed a law effectively trying to tax the National Bank out of existence within the state of Maryland. It argues that one, we Maryland have this power to tax, and two, by the way, this Bank of the United States is unconstitutional. What is the argument? Well, Maryland says, read your Constitution. The Constitution creates a national government of limited powers. Where is the charter bank clause in the Constitution? There's no power like that in the Constitution, so the national government should lose, and the national bank should be unconstitutional. But then John Marshall steps in and he says, no, Maryland, you're not interpreting the Constitution correctly. And what Marshall does here, and this is the key point from McCulloch v. Maryland, is that Marshall's saying that with the national government, yes, it's a government of limited powers, but it's possible to imply certain powers from those that are specifically listed in the Constitution. So for Marshall, it's not important that there's no charter bank clause. What Marshall says is that Congress has a range of powers in Article Section 8 that are related in important ways to establishing a national bank. Things like regulating interstate commerce, borrowing, spending for the general welfare, things like that. And what Marshall's saying is that the establishment of a national bank is related enough to those powers that when those powers are read together with the necessary and proper clause, it establishes Congress's authority to charter a national bank. Here's the key quote from Marshall. Let the end be legitimate. Let it be within the scope of the Constitution in all means which are appropriate, which are plainly adapted to that end, which are not prohibited, but consistent with the letter and spirit of the Constitution or constitutional. So what Marshall's doing is he's saying there's some flexibility for Congress to take actions that, though there's not a specific power in the Constitution, those actions are related enough to those specific powers that they're constitutional.
And is there a supremacy clause argument to be made here too? Do they factor that in as well?
Yes, the other part of the opinion is that Marshall also says Article 6 of the Constitution makes the Constitution and national law supreme. Maryland, you're trying to use a state power to destroy a legitimate national institution. The power to tax is the power to destroy, Marshall says. And so therefore, the Maryland tax itself is unconstitutional.
So those that necessary and proper clause and that supremacy clause are kind of the key constitutional provisions taken into account with McCulloch v. Maryland.
That's right, Jenna.
Okay, cool. So let's look at another federalism case, which is the United States v. Lopez. So what's going on here and what's the key takeaway?
Sure, now we're in 1995, closer to today. So in this case, it's Alfonso Lopez is arrested for carrying a concealed weapon into his high school. And so he's charged under a national law, the Gun-Free School Act of 1990, which bans guns in schools. Mr. Lopez comes to court and he says, but where, this law that Congress passed is unconstitutional. Congress says that it has the power to do this under its commerce power, but what does this action have to do with commerce? And so it comes, the background here is that since the New Deal, roughly since 1937, the Supreme Court had read Congress's commerce power really, really broadly. And United States versus Lopez in a 5-4 decision resets some limits on Congress's commerce power. So what the Supreme Court says here in an opinion by Chief Justice Rehnquist is, Mr. Lopez, you're right. This law exceeds the powers of Congress. Carrying a gun into a classroom is not an economic activity, and it's not substantially enough related to interstate commerce to justify a congressional law. And so therefore it's struck down that law is unconstitutional.
Yeah, so I love looking at Lopez and McCulloch next to each other because with McCulloch, it was the Supreme Court did find the provisions in the Constitution and therefore struck down the states. Whereas with Lopez, they couldn't find those powers granted to Congress in the Constitution, and so the state was able to make those laws. So that's there's that federalism coming into play again, right?
Yeah, so the Supreme Court, Rehnquist in part is saying, this is the sort of thing, regulating guns in schools is the sort of things that state and local governments usually do to promote the health, safety, and welfare of their residents. So we're going to leave that power with the state and local governments.
In the states and the national governments, kind of that division of power. Okay, thanks, Tom. That's super helpful. So going to a huge, like a pretty big bucket here of cases, looking at the Bill of Rights and balancing our personal liberties with, establishing order in the country and kind of where that line is. So let's look at some of these sort of key Bill of Rights cases, starting with Engel versus Vitale in 1962.
Yeah, it's the beginning of our quintet of First Amendment cases here. Engel versus Vitale is best known. It's a school prayer case. And so again, we're in the Warren Court. It's a 6-1 decision by Justice Hugo Black. What's happened here? New York's Board of Regents has authorized public schools to recite a short voluntary prayer at the beginning of each school day. And so this prayer reads as follows: Almighty God, we acknowledge our dependence upon thee, and we beg thy blessings upon us, our parents, our teachers, and our country. And so what we have here is we have some parents step into court and say, wait a minute, this prayer violates the First Amendment's Establishment Clause. And the Supreme Court here in a 6-1 decision says, parents, you're right. And in part, what seems to be animating the court's concern is the specific context of this being kids in a school and the possibility of coercion by teachers, by government officials, sort of forcing students to say things and profess things as to religion that they don't actually believe. So the Supreme Court, on the one hand, there's a huge backlash against this case, but the Supreme Court holds its ground, extends it to other contexts like graduation ceremonies and football games. At the same time, the Supreme Court over time has said that prayer is allowed in government settings where basically where it's mostly adults around. So say at the beginning of Congress or at the beginning of a town council meeting.
Okay, and so that is, like you said, that's a Establishment Clause case. That's if we're looking at what part of the Constitution we're talking about with this one, we're looking at that Establishment Clause of the sort of a religion umbrella, right?
Absolutely.
So moving on to the other half of the religion umbrella, let's look at Wisconsin v. Yoder.
Yeah, so this case, it's 1972. It's a unanimous decision by Chief Justice Warren Burger. And this case involves, as Jenna said, a First Amendment free exercise challenge. And so the two, it pits some Amish families against the state of Wisconsin. And so Wisconsin, like many other states, has laws in place that require parents to send their kids to school for a certain period of time. And what the Amish parents come in and say is that, okay, that's fine. We're willing to send our kids to school for a certain period of time, but only up until 8th grade. The concern being that once you get beyond 8th grade, their children aren't getting skills that they need to succeed in their Amish community. They can succeed with the education they've had then up to that point within the community. And two, they might begin learning things in high school that contradict the Amish values that community holds dear. And so they're saying, we want an exemption to this law. And so we see this in First Amendment free exercise challenges. It's often religious challengers coming in, and then there's a law that generally applies to everyone. And those challengers are saying, because of our religious beliefs, you shouldn't apply that law to us. And Wisconsin v. Yoder is important because it's one where the Supreme Court says, yes, religious challenges, you're right. So it's a pretty broad reading of the free exercise clause, granting this exemption to Amish families, saying you don't have to send your kids to school after 8th grade.
Okay, yeah, that's a big decision there. Okay, so we've done establishment, we've done free exercise. Let's move on to free speech, and specifically free speech in public schools, and our friends Mary Beth and John Tinker.
Yeah, so Tinker v. Des Moines is the really big school speech case. It involves these two students right here and those armbands. The context is it's during the Vietnam War. And these students go to school wearing these black armbands, and there's no great disruption in the school. None of that is established in the factual record. But in the end, they're punished for wearing these armbands. And then they go to court and say, no, schools, you can't do that. This is a form of symbolic speech protected by the First Amendment. And what the Supreme Court says in a 7-2 decision is that, Tinkers, you're right. The school is wrong. Here's the key language from the opinion. It can hardly be argued that either students or teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. And so here it's saying that there are First Amendment speech rights within the school context. The other piece of this, though, is that the court also establishes a certain amount of discretion for schools to regulate speech if it's done to, quote, materially or substantially interfere with the school's operation. And so this establishes for us that in the context of school speech, the government officials have more discretion to regulate speech than government officials outside of school. But in the end, that regulation, again, has to do with advancing the educational mission of the school. It has to be going after a speech that's materially or substantially interfering with that educational process.
Okay, so key things to take away from the Tinker case is that like schools kind of acting as state agents kind of still apply the First Amendment. There are limits, but those limits do not extend to if you're not disrupting school speech. And I love this. This case is still really relevant, not only for all of our students in school, but there was just a case last year that dealt with free speech in schools. It was Mahanoy versus BL, which was came out right here in Pennsylvania. So definitely relevant. All right, moving on to our freedom of the press. That First Amendment still getting a lot of play here in these landmark cases. So New York Times and Company versus United States, 1971.
Yeah, so this is also known as the Pentagon Papers case, and it deals with a particular kind of First Amendment issue, and that's the issue of prior restraints. And so prior restraint is an attempt by the government to keep someone from publishing something. And so classically, one of the most strongly established First Amendment rights is a right against prior restraint. We have a strong presumption against allowing the government to keep people from publishing things. Now, it's possible after you publish something, you could be punished for it under the law for a particular reason. But for the First Amendment purposes, there's a strong presumption that the government cannot keep someone from publishing something. The government needs a really good reason to overcome that presumption. This case involved the Pentagon Papers. So what were they? They were a classified Defense Department study examining the history of U.S. involvement in Vietnam. There was a man, Daniel Ellsberg, who worked for the Rand Corporation and knew about these papers. And he sat there and photographed 4,000 plus pages of the Pentagon Papers and sent them to reporters at the New York Times and the Washington Post, who began publishing them. The Nixon administration steps in and says, no, stop the presses. It could really harm national security. Newspapers, you can't print this material. So they go to court. And ultimately, the Supreme Court, in a 6-3 decision, says, no, the newspapers are right to publish this. In the end, Nixon administration, there may be embarrassing things in here. But the reasons you have given have not been enough to overcome this heavy presumption against prior restraint. And so the presses can keep on printing.
That'd be a lot of memory even today, that many pictures.
Yeah.
All right, cool. So we've talked about freedom of speech, freedom of the press, freedom of religion, both establishment and free exercise. So one more First Amendment case before we move on to the next grouping, and that's Schenck v. U.S. 1919. So tell us about this case, why it's important, kind of what were the big takeaways from this one?
Sure. So we're going back in time to the World War I context. And so the defendants here were mailing printed circulars designed to obstruct the military draft. And so what happens is they're charged under the Espionage Act of 1917. That act criminalized conduct that undermined the war effort. And the question was whether or not prosecuting them for this material they printed out and sent to other people, whether that violates the First Amendment. And here, it's a unanimous decision by the Supreme Court, authored by Oliver Wendell Holmes, that says it upholds the conviction. It upholds the Espionage Act of 1917. It says that the government can suppress this speech in wartime. And this case is significant to remember today because, one, Holmes establishes what's known as the clear and present danger test. And so it's a reminder that First Amendment freedoms are not absolute and that government can step in to regulate speech under this test if it creates a clear and present danger that then that government body has certain powers to attack. And then it's also known, though, for this famous line from Oliver Wendell Holmes: the most stringent protection of free speech would not protect a man in falsely shouting fire in a theater and causing panic. So Schenck establishing the First Amendment, not absolute, but it's important to note that the Supreme Court has moved away from this restrictive view of the First Amendment over time, in part inspired by later dissents by Oliver Wendell Holmes and Justice Louis Brandeis. And eventually, as we get into the 1950s and 60s, we see the Supreme Court move towards a test that provides Americans with the strongest free speech protections anywhere in the world, culminating in a case known as Brandenburg versus Ohio in 1969.
Okay, so back and forth a little bit with First Amendment rights, but the big takeaway from Schenck is that they're not absolute and there are exceptions. One big exception is that clear and present danger. I think we're all taught that you can't yell fire in a crowded theater. That's a very simple way to remember it, unless there actually is a fire. I think falsely is the important word there. Okay, so
yeah,
great.
and I mean, Schenck is just an example. I think for the court at the time, the war context made a big difference there, where it's thought that the danger was magnified by the context of war. But even today, we can imagine the Supreme Court coming out differently.
I think we've seen that. Again, we're not, we only have so many cases we can review today, but I think we've seen that kind of wartime exceptions in Supreme Court cases over the time too. Sure. All right, moving on to the next category, which is sort of incorporation. So cases that have incorporated the Bill of Rights. So let's take a quick beat and talk about what incorporation is and why that's important as a concept. And then we can get into the specific cases. So Tom, explain incorporation to us and why it's important.
Sure. When the Bill of Rights is originally ratified in 1791, it only applies to the national government. Chief Justice Marshall, in an opinion known as Barron versus Baltimore, said that that was true. It affirmed the Bill of Rights originally only applies to the national government, not to the states. Incorporation is the process through which we begin to apply key Bill of Rights protections like free speech, religious liberty, jury trial rights, all of those sorts of things to state abuses. It comes out of the ratification of the 14th Amendment in 1868 and later Supreme Court decisions. And what the Supreme Court's done over time is what's known as the process of selective incorporation. So they've incorporated new rights case by case, right by right. And with, again, like over time, the big idea is that we've incorporated nearly the entire Bill of Rights against the states. And so today, nearly all Bill of Rights protections apply just as much to the national government, state government, local governments, but that wasn't true at the founding. It's only through the process of incorporation that becomes true.
Okay, so let's take a look at a couple of the cases that did just that. First one is Gideon versus Wainwright. I love this one.
Yeah, so Gideon versus Wainwright is one of the classic incorporation cases. The picture there is Clarence Earl Gideon. He's charged and convicted of a burglary in a pool hall. He then is standing trial, and Florida does not give him counsel, even though he's too poor to afford one. And so Gideon goes to prison. He studies the Constitution. He says, I think under the Sixth Amendment, I have a right to counsel. And so he writes a handwritten petition from prison, sends it up to the Supreme Court. The Supreme Court reads it. They take his case, and ultimately through Gideon versus Wainwright, they say, Clarence Earl Gideon, you are right. And what the Supreme Court does here, importantly for incorporation, is that it incorporates the Sixth Amendment's right to counsel against the states. And so what this does is it throws out Clarence Earl Gideon's conviction, and because of incorporation, Gideon then gets a lawyer the next time he stands trial, and he actually wins his case. So it's a real classic reminder of the practical effects of incorporation. Before incorporating this right, Florida could deny someone like Gideon a right to counsel. After incorporation, they couldn't.
So this one reminds me a little bit of Marbury versus Madison, where there's the facts of the case and they're important, but there's this bigger kind of effect that comes out of the case, and that's incorporating. Like, it's great that Gideon got a new trial, but the fact that we've also were incorporating the Sixth Amendment is kind of even a bigger effect of this case.
For sure. It becomes memorable because of Gideon's story, though.
I know. I love he wrote it in pencil, right? Yeah. And I think you can see the document. I think it's online and stuff. So, all right, moving on. So the next big case is Roe versus Wade in 1973. So tell us about this case and why this one's important.
Yeah, so Roe v. Wade is all about whether or not the American people have certain rights that aren't specifically listed in the Constitution. So Roe v. Wade involved a Texas woman, Jane Roe, who sought an abortion. Texas had a law on the books banning abortion except in the instance when a woman's life is endangered. And what Roe argued was that law was unconstitutional. In a 7-2 decision, the Supreme Court, in an opinion by Justice Harry Blackmun, agreed with Roe. And what effectively the case did is it took a case from a few years earlier, Griswold versus Connecticut from 1965, where the Supreme Court recognized a right to privacy not specifically listed in the Constitution, but the court said that a right to privacy exists. It then applied that right to privacy to the context of abortion, and it said that there is a right to an abortion in certain contexts. Again, reaffirming the idea that there are certain unenumerated rights, certain rights that aren't specifically listed in the Constitution that are still protected.
So even though it's not listed in the Constitution, is there a portion of a part of the Constitution that you can point to that says like where they pulled that unenumerated right from?
So yeah, the unenumerated rights are traditionally pulled from a few different sources. One, some people argue that it's the Ninth Amendment. The Ninth Amendment says that just because a right isn't listed in the Constitution doesn't mean that you don't have it. Other people draw upon the 14th Amendment, either its privileges or immunities clause, or its due process clause. So there are different provisions that you can pull from. Effectively, if you read Roe v. Wade, Blackmun's opinion is largely doctrinal. So he's largely saying we're going to apply the reasoning we had in Griswold and we're going to apply it to this context of Roe v. Wade. Of course, this remains a hot topic of debate and conversation, et cetera, among lawyers, judges, politicians, et cetera. It remains one of the most contested issues in constitutional law.
Absolutely. All right. Thanks for that explanation, Tom. All right. Moving on to McDonald v. Chicago and our Second Amendment.
Yeah, so McDonald is a case involving the Second Amendment's right to keep and bear arms. McDonald arises 2 years after a landmark Supreme Court decision known as District of Columbia versus Heller in 2008, where it's the Supreme Court's really big Second Amendment case, where it says the Second Amendment protects an individual right to keep and bear arms, especially in the interest of protecting one's home. And the key context here is Washington, D.C. is not a state. It's a federal territory. So that case just happened under the Second Amendment. McDonald asked the natural follow-up question, which is whether or not we should incorporate the Second Amendment against the states. The case itself involved a law that was effectively a handgun ban in the city of Chicago. And in the end, the Supreme Court in a 5-4 decision says, yes, we are going to incorporate the Second Amendment against the states. We're going to strike down this handgun ban. The Second Amendment right to keep and bear arms, this individual right, is deeply rooted in the American constitutional tradition and therefore should be incorporated.
Okay, great. All right, so that's incorporation. I think we all understand that this slowly applying the Bill of Rights protections to the states through the process of selective incorporation, case by case, kind of protection by protection. Let's look at the next big grouping. Well, the next category only has one case in it, but that would be equality. And according to the AP, this category is the 14th Amendment's Equal Protection Clause, as well as other constitutional provisions have been used to support the advancement of equality. And I think one of the best cases to look at when looking at this is Brown versus Board of Education.
Yeah, Brown versus Board, it's 1954, certainly one of the most famous cases in Supreme Court history. This case involves the constitutionality of school segregation. And so this is the practice, Jim Crow laws that put white students and African-American students in different schools. And so what the Supreme Court had to do here was consider whether or not that violates the 14th Amendment's Equal Protection Clause. The challengers are parents and students, African-Americans, who were denied access to schools because of these laws in various states across the country and also in Washington, D.C. And, the case itself arises from decades of legal strategy put forth by the NAACP Legal Defense Fund and key lawyers like Thurgood Marshall that chipped away at Jim Crow segregation over time. And here, what the parents and students are arguing before the Supreme Court is that school segregation violates the 14th Amendment's Equal Protection Clause, but also they're urging the Supreme Court to overrule its own decision in Plessy v. Ferguson from 1896, which said that separate but equal facilities are constitutional, so upheld Jim Crow laws like these. In the end, the Supreme Court, in a unanimous decision by Chief Justice Earl Warren, said, parents, students, Thurgood Marshall, you're right. These Jim Crow states are wrong. We, the Supreme Court, were wrong. Plessy v. Ferguson was wrong the day it was decided. School segregation violates the 14th Amendment's Equal Protection Clause. And here's Chief Justice Earl Warren. We conclude that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal.
That's so powerful. And I think that another thing to remember, and I wanted to point out about Brown versus Board, is that this is a really important, really powerful decision from the Supreme Court, but it would take actions of the other branches of government to kind of really enforce the Brown v. Board decision, right, Tom?
Yeah, it would take the court itself in future decisions, lower court judges. It would take enforcement by the different state governments, and also actions by Congress and the president, including landmark statutes like the Civil Rights Act of 1964, which is 10 years after Brown.
All right, so our next category is looking at kind of campaigning and electoral rules, and our most current recent case on the list, which is Citizens United. So tell us about Citizens United v. Federal Election Commission in 2010. Why is this one important?
Yeah, so this has to do with the First Amendment again. It's dealing with independent political expenditures purchased through corporate spending. And so here, this case involves something called Hillary the Movie. It was a movie put out by Citizens United that was critical of Hillary Clinton during the 2008 presidential primary. Part of the contributions to this movie came from corporations, and that ran afoul of a law of Congress which banned political spending by corporations and labor unions. So Citizens United comes to the Supreme Court. It challenges that law, that ban on political spending by corporations and labor unions under the First Amendment. And the Supreme Court, in a 5-4 decision, says Citizens United is right. It strikes down that ban on corporate spending. And what it effectively sets up is really, I mean, it's in many ways, it's consistent with some of those earlier decisions we saw, where it's the First Amendment really is a potent constitutional provision that strikes down a lot of laws and sort of in the interest, in this case, from what Justice Kennedy said, of sort of promoting as many voices as possible in the public sphere and as many ideas as possible. And so casts a critical eye on Congress trying to regulate that. Again, it's a 5-4 decision. So there's great disagreement among the justices. And this remains, again, another one of those cases that continues to be debated by a range of people in the legal world and in politics.
So, and I just want to reinforce what you said there about the reasoning behind the case is that they wanted the spirit of the First Amendment is to get as many voices and opinions and thoughts out there. And so that's why they kind of sided with Citizens United in this case.
Yeah, so like there was an earlier decision upholding a ban like that on corporate speech. The interest involved in that case was the Supreme Court said it was okay to sort of try to equalize the voices of different people. So maybe taking away some of the power of those with money to try to equalize the voices in the marketplace of ideas. And the Supreme Court and Citizens United, the majority is saying, no, the Supreme Court got it wrong in that case. And we want a more libertarian and free speech environment.
Got it. All right. So that makes a lot of sense. Thanks for clarifying that, Tom, because I think that's one where people get a little stuck. All right. Looking at the structure of the, this is our last category, students. So I know we're a little over time, but we'll get through these next 2 cases. And then I will get to questions both from YouTube and in the chat. So we will stay after. So if you've been submitting questions, we'll get to them, I promise. But I do want to get to this last category, which is according to the College Board and the AP structure about the legislative structure of the legislative branch, but it's also a little bit about representative equality or equality in representation. So we'll look at Baker v. Carr in 1962 and then Shaw v. Reno in 1963. So Tom, tell us about Baker v. Carr and why that one's important. What are the takeaways?
Yeah, so Baker v. Carr is part of the Warren Courts, what's known as the reapportionment revolution. And so this is, the context here is it's Tennessee. The Tennessee legislature has established legislative districts 6 decades earlier and hasn't updated them since. And so you have Tennessee citizens coming in and saying, no, what you're doing there is you're creating unequal votes in different districts. You're not having the districts tethered to the population. And so over time, population shifts have put more people in urban areas, fewer people in rural areas. And by not updating those districts, what you're doing is making certain votes count more than others. Now, in 1946, the Supreme Court had said, we're not going to get involved in these sort of apportionment decisions. Baker v. Carr is significant because it's a 6-2 decision by Justice Brennan saying, yes, we will get involved in these sorts of situations. You can bring 14th Amendment Equal Protection Clause claims saying that votes are unequal and that we should be stepping in and forcing districts that are roughly equal in population. And ultimately, 2 years later, in Reynolds v. Sims in 1964, that's exactly what the Supreme Court does. It establishes that principle of one person, one vote, which is that we really want our legislative districts equal in population, so everyone's vote counts the same.
Okay, so that's good to know. So that's like you said, one person, one vote, that equality across representation, and that really we dig even further into that when we look at Shaw v. Reno. So tell us about that one. That's from 1993. Tell us the key facts of this case and why it's important to learn about it and those key takeaways.
Yeah, so Shaw v. Reno has to do with the issue of racial gerrymandering, and so these are challenges brought against legislative districts saying that the legislature has taken race too much into account. And Shaw v. Reno involved districts in North Carolina. In particular, it involved that pink district you can see in the middle there, which is, sort of what the legislators did is basically draw a district along an interstate highway, I think is what happened. But challengers came in and what they said is, what the legislature is really doing here is trying to create districts based on race. We know this, part of the reason we know this is because the suspicious shape of that district. And what the Supreme Court does in a 5-4 decision by Sandra Day O'Connor is saying, yeah, that is something that we need to police. We need to police racial gerrymandering. We don't want race to be the overwhelming factor in these decisions. And so when challengers come in and can point to a map and point to a suspiciously shaped district, say, what we're going to do is we're going to ask the state to justify their decisions. And if they can't come up with a really, really, really good reason that doesn't have to do with race, then we're going to throw out those maps and force them to rewrite new ones.
Awesome. Thanks, Tom. Those were some really great explanations. I hope that we clarified everything. We do have a couple questions, so I'll ask you to stick around after we officially end class. But before we do, any final words or final thoughts for our students?
Not at all. Just good luck on the exam.
Yeah, good luck, everybody. I hope you do well, and we'll be here for you. We're gonna take a couple questions. I know there's YouTube questions. I just need to pull up that feed. So thanks so much. Talk to you soon.